You brought a medical malpractice lawsuit claiming your doctor caused you significant harm and injury. Now your case goes to trial. You have a medical expert who testifies. The defense has a medical expert who testifies. And you decide you want to bring in another medical expert to rebut the claims made by the defense's expert. Can you do that at the last minute? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and in all likelihood, the answer will be no, you can't. Just because the defense has put on an expert who has rebutted many of the arguments that our expert has made, and you feel in your own mind that the defense's expert came across better than your own expert, we can't simply go ahead and now quickly hire another expert to come in to go ahead and say the same thing, to reinforce what our first expert said. That's known as cumulative testimony, where you're stacking one type of testimony on top of the other to bolster it, to reinforce it. That's not allowed. If, however, the defense's medical expert brought up things that were never addressed by our first expert, it is possible to ask the judge for a rebuttal opportunity to bring back our original medical expert to now address those specific things that were never discussed during the course of the original testimony. If this defense expert opens the door, the judge may give us a very limited opportunity to bring our medical expert back. Now, there's some very, very limited instances where something new comes up during the defense's medical testimony. In that instance, the judge may allow us to go ahead and get a different medical expert to come in to now try and rebut those particular arguments. But trying to do that will be extremely difficult for the principal reason that we have never notified the defense that we have another expert, assuming we do, and even if we don't, to try and get one in the last minute who now comes into court to testify, the defense will turn around and argue, "Judge, we knew nothing about this expert. We don't know anything about this expert. We don't know his credentials. We don't know what he's done. We don't know what he's going to say." And now it'll be a battle, a legal battle between the attorneys trying to convince the judge that yes, we should be allowed to bring in this other expert. In all likelihood, that's not going to happen. So why do I share this great information with you? I share it with you because you may get the perception that simply because the defense has the last word and you think he has done better than your own expert, you may feel you want to bring in additional witnesses to support your claim to not only get the last word, but to show that you have a valid case compared to what the defense has said. You know, I recognize and I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.